just to say, these everyday rights conversations are a product of the UK Economic, Social and Cultural Rights Network. And if you're interested in getting involved in that network, my colleague Laura is going to share a link in the chat. She'll also share the link to the feedback form. And also our next session is going to be on rights enjoyment, and it's happening later in June. So Laura will also share the link for that in the chat. But that's all you're going to hear from me for a little while, and other than introducing our speakers. And the first speaker I'm absolutely delighted to introduce is my colleague, Kate Ewing. Kate is a researcher at Just Fair, and alongside her work at Just Fair, Kate's working on a PhD at Pompeu Fabra University in Barcelona. The focus of Kate's work there is work time and also the minimum wage. And Kate previously worked in London as a labour rights solicitor representing trade unions and their members. So over to you, Kate.
Thanks, Helen, and hi, everybody. It's really nice to be here today and see so many people joining despite being a bit late in the evening. I'm just going to try showing my screen, so a couple of slides, and then I can get started. There we go. Can you see that okay? Yeah, okay, great. So as those of you who've attended our previous Everyday Rights discussions will know, this is one of a series of events organised by Just Fair to talk about incorporation of everyday rights into everyday life for everyone in the UK. And by this we mean everyday rights like having a decent job, a place to call home, a place to learn and pursue education, to have good physical and mental health, amongst others. And by incorporation, we mean not only the legal frameworks needed, but all the policies and mechanisms surrounding that to make sure that people actually experience their rights. So this really is an opportunity to think about how we bridge the gap between the promises of the international legal protections for economic, social and cultural rights and the reality as it's experienced by people in their everyday rights in the UK. Just Fair has developed 5 principles to help us think about this and guide these discussions. And we hope that through this process, we can gather together all of our expertise and ideas to think about how we can best achieve the goal of rights incorporation across the whole of the UK. I won't go into all of the 5 principles in detail. Instead, I'd encourage anyone who hasn't been to a previous session to check out our online resource page and also sign up for the upcoming sessions that Helen has mentioned. But very briefly, the 5 principles are rights knowledge, rights frameworks, rights resourcing, rights accountability, and rights enjoyment. And so the focus of today's session is on that 4th principle, rights accountability. So what do we mean by rights accountability? Well, for Just Fair, rights accountability is a critical part of transforming rights from theoretical protection on paper to daily reality for people. Accountability requires that there are consequences where things go wrong and protections fall short, and that the consequences result in meaningful change. Rights can be seriously undermined by the lack of accountability and lack of accessible accountability. And we think that rights should be proactively protected and their guarantees should form part of decision-making by duty bearers. But of course, that means having systems in place which require and encourage this. And when there's a failure to protect rights, that people are able to complain and for there to be adequate remedy or remedies which are accessible and are delivered in a timely way is clearly critical. And so that involves having measures to facilitate the process, to support and protect complainants. And so systems must be well designed and be accessible and remove barriers. And the reality in the UK is that far too often this is not the experience of many people. I mean, if we look at the recent news about Grenfell families having to wait until at least 2027, 10 years after the terrible fire, for any prosecutions to even start of those suspected of being responsible. or we look at the high number of social care workers who continue not to be paid correctly for their work time, despite this being a legal requirement as part of minimum wage law, and the difficulties they face in pursuing the sums owed to them. Or research that was carried out in Wales and was reported by Race Equality First in our submission to the UN Committee on Economic, Social and Cultural Rights, which highlighted the extent to which minority ethnic pupils experience race and identity-based bullying in school, and how many of them felt that they didn't feel confident to tell their teachers based on past experience of previous incidents not being adequately dealt with. These are just 3 examples of the search for accountability in relation to specific economic, social and cultural rights: the right to adequate housing, the right to just and favourable conditions of work, and the right to education, amongst others. And so in developing our work on a UK-wide vision of rights incorporation, we're hoping discussions like this will allow us not only to recognise these very real difficulties and problems that people encounter, but also to think about all the measures and mechanisms needed to make rights incorporation an actual lived reality. And so I'm really looking forward to tonight's discussion, and thank you so much for being here. And with that, I'll hand back to you, Helen.
Thank you so much for that, Kate. Already quite sobering. Some of the issues you're discussing there and the ways in which people are unable to effectively get accountability. But I'm going to pass quickly on to our next speaker, who is Nuala Toman. Nuala is the head of innovation and impact at Disability Action. She is a fellow of the Centre of Democracy and Peacebuilding, and as a deaf and disabled person, Nuala has worked to close the gap between decision makers and deaf and disabled people. Nuala is the author of Progress Towards the Implementation of the UNCRPD and the Pedagogy of Lifelong Learning. And Nuala is a member of the All Ireland Women's Forum, a board member of the Northern Ireland Museums Council, and Conradh na Gaeilge, as well as the Human Rights Consortium. I'm going to pass over to you now, Nuala.
Thanks, Helen. So, as Helen has introduced me, I work for Disability Action, which is the largest disabled persons-led organisation in both the UK and Ireland. And although we operate mainly within the north of Ireland, and what we've seen recently is that disabled people have just been through the worst, well, I would say we're kind of emerging from, although still feeling the severe impacts of the worst political, economic, health, cost of living and public finance emergency that we have had since the implementation of the Good Friday Agreement. So in this part of the UK, disabled people's rights have been breached day and daily, and most recently through a series of cuts that were implemented by non-elected civil servants when the political institutions were not operational. So just think about that for a minute. So in this part of the country, people who were not elected were given powers which they used to decimate services and undermine the rights of disabled people without a whisper. And now that our political institutions are operational, no action has been taken by the local executive and assembly to redress those cuts. So in this jurisdiction, it's really essential that people's social, political, economic and human rights are protected, and that we have access to accountability mechanisms through which to realise those rights. And I know there is a wider discussion across the devolved nations that's looking at incorporation of international human rights instruments into law. And in some jurisdictions, like Scotland, that would involve amending the devolution settlement. Now, obviously, in this jurisdiction, things are a little bit different because we do have part in relation to equality that other developed nations don't have. But there's a considerable amount of nervousness anytime, because what we have in this jurisdiction is an accommodation that is part of a peace process. So there is nervousness at any point around disrupting any aspect of that particular settlement. So recently, the United Nations conducted a follow-up review of the special inquiry into the UK government and the Northern Ireland Executive in respect of progress in respect of largely around the implementation of welfare reform, but looking at the rights associated with an adequate standard of living, independent living, housing, etc. And that follow-up inquiry concluded in March that both the UK government and the devolved administrations, including the Northern Ireland Executive and Assembly, have engaged in the grave and systematic violation of the rights of disabled people. Now, for us in Northern Ireland, the original hearing for that inquiry was to be held in August 2023. At that time, those brutal cuts taken forward by unelected civil servants had just come into force. But the UK government didn't appear, and as a result, the hearing was postponed, and the outcomes then were only published in March, which limited any kind of input that we would have wanted in terms of any negotiations around the re-establishment of the political institutions. Interestingly, the UN committee did recognise that those cuts breached the rights of disabled people, and also noted that the executive have taken no action to redress them, which we can use as a campaigning point. But in terms of accountability, it's really frustrating in that the UNCRPD is internationally binding, but it's not treated in that way within the jurisdiction in which we live. We are taking forward a case to challenge those cuts under Article 2 of the Protocol/Windsor framework, because as a result of Brexit, there is a commitment here towards the non-diminution of rights. So we're taking leave for a judicial review against the Department of Health under the grounds of Article 2 of the Protocol, in which we allege that they have breached the rights of disabled people, and we have a leave hearing scheduled for the 25th of September, and it'll be really interesting to see what emerges from that case, as there have been two really interesting judgments in respect of Article 2 that have placed this as a paramount instrument in this jurisdiction in terms of protecting the rights of people. So one was a judgment in the Legacy case that ruled that the Legacy Act was non-compatible with human rights issues here. And the second judgment is in relation to the Illegal Immigration Act. So we hope by raising this case that we create a space for greater accountability of human rights, and that other civil society organisations within this jurisdiction will see the benefits of actually challenging decisions through Article 2 of the Protocol to look at ways in which this can enhance human rights protections. And there are lots of other examples that we can go through as the discussion proceeds in relation to other statutory instruments that are not effectively used within this jurisdiction. But I think I'm about up to my 5 minutes, Helen, if not a little over.
Yes, thank you so much for that, Nuala, and I am so delighted to be on a call where I am not the only one banging on about the huge accountability gap in Northern Ireland when we don't have a functioning executive. So thank you for making me not the lonely voice in the room. But without further ado, I'm going to go over to Matt Creagh, and Matt is a TUC Employment Rights Policy Officer working with unions to campaign for improved labour market enforcement and better protections for migrant workers. Before this, Matt project managed the TUC Union Modernisation Fund project on precarious employment. So over to you, Matt, please.
Thanks. Hi, everyone. So my focus is on labour rights and how effectively these are enforced. And just drawing on what Kate said about rights accountability, I think the enforcement of rights is how we transform those employment rights from a theoretical protection on paper into a daily reality for people. And I think, unfortunately, for many workers, access to employment rights is not a daily reality. So I'd just like to highlight 4 areas where I think the enforcement of labour rights is problematic and not working for everyone. So the first area is around low-paid workers. So all workers have the right to the national minimum wage, but the Low Pay Commission estimates that 335,000 workers are still paid below the national minimum wage. So despite having rights to a tribunal and there being an enforcement body with responsibility for this area, it's not being enforced properly. Some low-paid agency workers have rights set out under the conduct regulations, which set out important rights like agencies not withholding pay or charging additional fees. But there's a very narrow route for enforcement for those workers. You can only go to the enforcement agency called the Employment Agency Standard Inspectorate, and you don't have a right to go to tribunal. So we think those workers are denied access via that route. And then holiday pay as well. So recent TEC analysis has shown that 2 million workers don't receive their paid holiday entitlement, costing around £1.6 billion for those workers. And holiday pay is not enforced by any regulator. So in that case, workers only have the option of going to bring a claim at tribunal. And that leads on to the second area where I think there are issues with the enforcement system, which is around employment tribunals. So there's a lack of resources. There's large delays, and this government was trying to introduce fees. So, for example, a survey of employment lawyers, 40% said that their clients are waiting more than a year to be able to bring a case to tribunal. So I think, for example, if you're a low-paid worker and you've been underpaid £200, is it reasonable to expect that worker to wait over a year to try and get that money back from their employer? And in reality, will they do so, or will they just give up on the claim? And the second area I wanted to flag up about employment tribunals and the barriers to access are around the fees that the current government is trying to introduce. So in 2013, the Conservative government introduced fees, and despite Unison, the union, defeating that fees regime in the Supreme Court, and the Supreme Court found that fees were unlawful. The government's repeating its mistake and pricing workers out of justice that way. So if you're a low-paid worker and you have a fee to pay before you can access justice, we think that would put workers off from bringing claims. The third area I wanted to flag up is around regulators and the employment rights enforcement bodies themselves. So firstly, they've got a very narrow remit. So if you're an agency worker, for example, you can only go and seek the help of a regulator around a very narrow set of issues. They don't enforce employment rights like the agency worker regulations, ironically. And if you have to use an umbrella company, which is a labour market intermediary that skims your wages, you can't go to a regulator. They won't be able to help you there. And with the employment rights enforcement bodies and the regulators, there's also massive resource issues. So in the agency work sector, there's 19 inspectors to regulate a sector where there's 1 million agency workers. So they can't possibly carry out a proactive investigative role. And the Gangmaster and Labour Abuse Authority has published that they're going to be experiencing budget cuts over the next few years as well, so reducing the effectiveness of their enforcement. And then the fourth area I wanted to flag up is that some vulnerable groups of workers are practically unable to enforce their rights. So seasonal migrant workers are one example where they've been totally failed by the Home Office and enforcement bodies. There's widespread evidence of mistreatment, both in the media being reported to trade unions and independent reviews which have been given to the Home Office, found that the Home Office knew about the exploitation and failed to tackle it. So I just wanted to briefly finish off 3 quick points, like how could we make employment rights enforcement more effective? I think firstly, we could have a much bigger role for trade unions, including a right to access workplaces, which would include a right to investigate and access employer documents so they could find out if employment rights are being breached and work with employers to rectify those issues. we're hopeful that if there's a new Labour government coming into power, they've got something called the New Deal for Working People, which is a much wider range of employment rights and commitments to improve the enforcement system. And then finally, I think being innovative and thinking of new ways to enforce employment rights, not just doing the same thing over and over again. So that could be, for example, making large contractors at the top of supply chains legally accountable for employment rights breaches that happen throughout those supply chains. Thanks.
Thank you so much for that, Matt. Fairly bleak picture of the current condition of employment rights, but I really liked your looking forward, the investigate, the enforce, and the innovate, including, you know, legal implications. It sounds like some really, really practical steps forward. So thank you hugely for that. And then our final introductory remarks are going to come from Louis-Philippe Yanez, who Dr. Yanez is an international human rights lawyer and the Scottish Human Rights Commission's expert on economic, social and cultural rights. So over to you, Louis.
Thanks, Ellen, and thanks for the invitation, and thanks everyone for coming. Great to see some good friendly faces that I haven't seen in quite a while. I'm just going to put my time before I forget. Here we go. Okay. So the first, I probably want to try to wrap up some of the discussion today, and has to do really to how to ensure accountability for the everyday rights, for economic, social and cultural rights in practice. And Matt was alluding to a few really relevant things, which is to do with some of the scrutiny bodies that we have and some of our tribunal system that we have in place. And I want to sort of broaden that discussion. We often think about accountability of rights, and we often focus too much on the courts and the court system, which is essential, which is really important. But when we talk about access to justice, we also have to think about the wider parameters of our structure, and it might depend on country by country. So particularly for the UK, we're looking at what we sometimes call our RIOs, our regulators, our inspectorates, our ombudspersons, and our national human rights institutions. This is what some people, including David Barrett from the University of Exeter, has called the everyday accountability mechanisms. And he's done some quite interesting research that some of you might want to look at. And when we look at the everyday accountability mechanisms, we're looking at really who holds some of our duty bearers to account, sometimes not necessarily in the public domain, but they are tasked with that level of scrutiny. I think it's one of the really important elements to discuss when we look at these obligations that are subject to progressive realization. Progressive realization, the maximum available resources criteria, the non-retrogressions obligation. How do you determine that things are getting better or are getting worse? And the key for some institutions not to look at things on a day-to-day, on a case-by-case basis, but looking at sometimes the wider structure. And in that sense, one of the things I've been asked today to speak about is the role of watchdogs, and in my case, for myself at the Scottish Human Rights Commission, the role of national human rights institutions. So we need a national human rights institution. In the UK, we're quite unique from the rest of the world. We have three, and that's given our devolved settlement. We have the Equality and Human Rights Commission, which is the equality regulator, and the National Human Rights Institution for England and Wales. We have the Northern Ireland Human Rights Commission for Northern Ireland, and we have the Scottish Human Rights Commission for Scotland. What we have is a quite unique level of disparity between the powers and the structures of our three NHRIs, which means that there is a level of disparity in the rights protections across of our devolved nations. But we also have to reflect really carefully of ensuring that if we're bringing rights into our legislation, if we want to embed our international everyday rights, our economic, social and cultural rights in our domestic legislation, we need to make sure that our watchdogs, our scrutiny bodies are well placed, are well resourced, really fundamental, are well resourced, have good governance structures, and are placed with the sufficient powers to really be able to hold government and duty bearers to account. So what are they? And I'll just sort of briefly touch upon them. Well, first, we need to make sure that they are able to give advice to institutions and advice to victims. We need to make sure that victims are able to go, we know that sometimes the justiciability of economic, social, and cultural rights can be really complex. So we need to make sure that we have the institutions that are able to give advice to victims to know where to go, how to go, when to go, and how to make their rights well protected and realized. We need to make sure that NHRIs have the power to raise proceedings, so they have the power to go to court, which means that they can address not only an individual issue, but they can address a systemic issue. They can bring cases that can be quite transformative, protect hundreds, if not thousands of people on a similar issue, and can also hold the risks that we know are associated to judicial proceedings, the cost, the long time, etc. That is something NHRIs can do well, and we have examples of what that has, for example, happened with ESC rights in South Africa with the South African Human Rights Commission. We need to make sure as well they have power to make investigations and do inquiries into probably issues where you might not want to have a full judicial proceeding, but we want to uncover things, and we want to make sure that both there is bad practice that is addressed, but we also want to encourage where there is good practice, that is learned in other influences. And from my own work doing regional monitoring across Scotland, I see where councils are doing things really well, and I actually want to encourage other councils, for example, to learn from that and take a similar approach. So that type of investigations are really important. The final two things, the final two powers is the power to compel information. In the UK, we have huge data gaps. We have a lot of gaps and silos of information that we actually don't know what is happening. We don't know where things are at in terms of rights realizations. We have data that is just not available. And so the NHRI needs to be able to create that information, ensure that the duty bearer is providing, so we can assess, are they meeting their obligations or are they not? And then that, again, escalating, does this require an investigation, or worse, does this require to go to court? And the final one, which is actually similar to what Matt was saying, is a power to make unaccompanied and unannounced visits. And this is a power that some NHRIs across the world have. I think it's something we often only really think about in terms of people deprived of liberty. We think of prisons, but it's actually really relevant for ESC rights as well, because you want to be able to visit, for example, social housing unannounced and really determine, are the conditions that a person are living there are appropriate or not. So this is the type of structure we need to make sure that our watchdogs really have if we want to make, at the end of the day, the rights that we incorporate in our legislation a reality and justiciable and strong. So I'll stop there.
That was wonderful. Thank you so much, Louis. And thank you to all our speakers for being so untimely. I think you had a lot of really great ideas synthesized to such a short time period. And participants will have already received a lot of your publications that I believe you were the lead author on, but I'll also be popping those up on our resource page afterwards. So there's a lot more reading and thinking to be done if that's an area that you find as fascinating as I do. But what we're going to do now is we're going to take each of the 4 questions in turn and we're going to discuss them. So I'm going to read out the question, I'll pop it in the chat, and then we're going to be asking people to come in and I'll just kind of chair that session. So the first question is, and our panelists have maybe touched on this a bit, what systems and processes for accountability already exist but aren't working properly or being used properly? How do we make the duties on decision makers effective so that they protect people's rights? Are there examples of laws which could be made more effective, more protective with minor amendment or with different implementation? Does anybody want to kick off with that one?
I don't mind going first if you'd like.
Go ahead, Matt.
So on the resources for accountability that already exist, I think, like I mentioned in my introductory comments, we've got the 3 main employment rights enforcement bodies. So you've got the HMRC, NMW enforcement team, Gangmaster, Labour Abuse Authority, and the Employment Agency Standard Inspectorate. So you have the frameworks there. I think one of the things that we're calling for is a large increase in resources and inspectors. So the ILO has benchmarks around how many labour inspectors you should have. They say for every 10,000 workers, you should have one inspector. And I think we're sort of 1,800 inspectors short. So that's one area where you could pump some more resources into the system and make it more effective. I also think if you've got government departments who have a lot of resources to protect workers and safeguard workers' interests, but at the moment they fail to do that. In particular, the Home Office, which has shown a real disinterest and detachment from any sort of worker protection focus at all. All they're focused on is reducing migration, making sure workers return at the end of their visas, and not on whether someone's getting paid or severely exploited whilst they're over here. So I think that's a large untapped resource, which hopefully a new government would utilise to better protect workers. And then I think that another area where you've got a resource for accountability that doesn't really exist is employer accountability. So I mentioned about supply chains. You've got really large employers at the top of supply chains, like supermarkets, for example, or retailers who could exercise an enormous amount of leverage over the supply chain and really sort of raise standards throughout that. And that's not being used effectively because ultimately the employers aren't accountable for what happens in their supply chains. So you could make some minor tweaks to legislation and said, for example, strict liability to say if you don't pay holiday pay throughout your supply chain, the large contractor will have to pay that for everybody. And I'm pretty sure that their practices would change overnight and they would start looking at what was happening in their supply chain and really, really make some changes.
Thank you so much for that, Matt. And Louis, I see you want to jump in. Go ahead.
Absolutely. I mean, I won't obviously repeat myself because I think I've covered the question in some degree in relation to national human rights institutions. I do think it's important to emphasize of what can be used but cannot be used because of our legal system. So, for example, we have a quite a strong judicial system, but we don't have rights that are justiciable to actually use the courts. So of course we don't, we have good protections in relation to housing standards in Scotland, for example. We don't have a right to housing protected in law. So while we have a good functioning, very strong judicial system, we can't use the judiciary to enforce our internationally recognized right to housing. So, there's an element of that really that's important about our sort of legal system. And I think, what Matt is alluding, which is really strong, which is we have really good, really important employment protections. But in some other areas of ESE rights, we have, and particularly social rights, we have no protections whatsoever or standards that are here and there. And I think that is a really important point. I think as well, we have a lot of really under-resourced scrutiny bodies. I think that's really important to say. Some of them have good powers, but are not resourced well enough. And I think often, in my personal experience, they don't necessarily communicate that often enough. So we don't realize that part of their failings is to do that they have not been resourced enough to do their work. And so I think a lot of our work needs to emphasize, and I say we as a community emphasize of how do we make sure that the institutions we have are made strong enough and robust enough. And the final thing I would say is we have a lot of scrutiny bodies which have the power to make recommendations, and that's where it stops. And so we have a lot of very good recommendations that unfortunately never lead to anything. So we need to reflect about, do we want these bodies to have a more quasi-judicial nature in which we have binding advice, we have binding recommendations? If there is an insistence of not using the courts too much, well, or the role of Parliament, for example, that's been another debate. If the scrutiny bodies make recommendations to Parliament where the Parliament can really hold government and authorities to account, there's a lot of that. We just see a wealth of discussion saying we've all identified the same problem. We know what the potential solutions are. We've worked with third sector and rights holders to identify those issues and the solutions, and nothing is done because that's the limit of the institutions we have. So how do we change that? How do we make that compliance really a reality is one of the big steps that we need to think about.
Thank you so much. And Louis, as you say, and like the amount of resources that go into getting to those recommendations, and then what's the point if nothing's changing? And Nuala, did you want to come in?
So in this jurisdiction, we have lots of statutory instruments that could be used effectively. The issue is that they aren't. And to put it in context, here the Chief Commissioner of the Equality Commission said that our lack of equality protections and the gap between, this is specifically around legislative protections, between here and the rest of the UK and Ireland is so vast that we are at risk of no longer being considered to be a developed country. So that's really a stark kind of indication of the level of human rights abuses and breaches of equality that we see day and daily. But in spite of that, there are statutory instruments that could be used to better protect people. We have Section 75, which gives a due regard for equality considerations to be addressed in policy and legislation. It also contains a duty to mitigate. This is not used effectively. And there is the potential for Section 75 to be used as a budgetary tool. The Equality Commission produced guidance on that. If that happened, it would really change the nature of this place. We also have a statutory duty placed on the executive to target resources on the basis of objective need. That has never been used except for in a very minor way in the Department of Education around school meal entitlement. But if that was used, it would change, vastly change how resources are allocated towards addressing challenges such as poverty, disadvantage, and the breaches of human rights. We also have an unrealised commitment for a Bill of Rights within this jurisdiction that would be an overall game changer in terms of opening up that protection through the courts that Louis was just referring to. And we also, have a continual disregard of the need to advance human rights because of the nature of armed force coalition. So effectively, through our government structures, human rights issues don't progress because of divisions within the executive. Both our commissions are under-resourced, and there is currently a case underway that's looking at what requirements the Equality Commission have in terms of working with the executive around budgeting. So it'll be interesting to see what the outcomes are of that case. So unlike other areas, we really do have to turn to the courts here because we lack, we lack commissions that are properly invested in and respected, and we lack the opportunities for government to enact progressive legislation.
Although I would add to that, Nuala, sometimes even when we do turn to the courts, and I'm thinking the anti-poverty strategy that the Committee on the Administration of Justice won a successful judicial review on, it must have been 7 or 8 years ago, and yet we still do not have an anti-poverty strategy in Northern Ireland. So even when we do go to the courts, they're not always the answer in terms of accountability. But did anybody else want to jump in there on, sorry, Kate, go on ahead.
Yeah, thanks. I think it's really interesting that there's always like sort of two ends of this, which is the sort of structural sort of reforms about talking about, well, do we want to rely on the courts? Do we want to use different mechanisms for enforcement? But then there's also the issues like better use of laws that we currently have. And so like just picking up on the issue around minimum wage, for instance, just as an example of like, there are examples that you can look in that's a really, as Matt said, a really badly enforced protection, which is contained in the International Covenant that we're entitled to. But there are mechanisms within that, for instance, that are either understood and not utilised, like the right to inspect records, but that requires you having the support of a trade union. It requires you knowing about it. It requires you having the confidence to do that. It's particularly difficult if you're in precarious work arrangement. And there's also a power that hasn't been enacted within the Act, which would require effectively employers to put minimum wage compliance statements on pay slips. And that's like an immediate sort of step of employer accountability. It's an immediate step, or it would help with supply chains. It's a step where the worker is then given information that they can check, that they can complain about. You wouldn't necessarily have to go to a tribunal. And it brings about transparency, which is, you know, so the element of accountability is about having places where you can enforce your rights, but it's also about all the stages along the way, the information that you need to, you know, to know your rights, to be able to articulate what's happening to you. And I think those are important things to look at as well in terms of how you build towards that sort of better incorporation for people.
Thank you so much for that really good analysis, Kate. Does anybody else want to jump in on that question before we move on to question 2? Okay, I'm going to move on to the next one. But as always, if we want to jump back and anybody has anything else that jogs their memory that they want to say something, do feel free to return. But question 2 is hopefully looking a bit more towards the positive. What are the examples of good practice or good initiatives that we're aware of and could use to build upon? We're interested in where these are happening, so it doesn't necessarily need to be within the UK, how they are working, but also why they are working well. Does anybody want to kick us off on that question? So examples of good practice.
I've got an example from the Midlands textile sector I could share if that's helpful. So yeah, I think mainly in Leicester, the textile sector there, it was quite renowned for being highly exploitative and people not getting paid the correct wages and sort of forced labour. So what happened there is the unions came together with the large retailers and came up with these sort of supply chain agreements, which I think were pretty much like collective agreements. And what the large brands agreed there is that the unions and community organisers could enter any of the suppliers' factories, workplaces throughout the supply chain. So they could go and speak to workers, find out what the issues were, and try and resolve some of the issues. And that's been quite successful because it's led to the recovery of unpaid wages for workers. So it seems like quite a good model to sort of facilitate trade union entry into workplaces, but also addresses some of the problems with the enforcement system, like speedy resolution and people not having to go to a court or spending money on solicitors to resolve issues. And then I think that like there have been some issues with that model. Like, for example, what if a supplier just says, well, no, we're not letting you in, which has happened. How do unions then enforce that? How do they go and sort of speak to the suppliers, the large brands, and say, well, the supplier's not letting us in, what are you going to do about it? And I think also on a practical resource point of view, it takes quite a lot of effort for trade union organisers and officials to go around and do that. And what the unions have seen is that hasn't necessarily translated into increased membership. So then questions get asked about, well, can we sustain doing that in the longer term when we're just sort of going around and providing a service to people and people aren't sort of organising themselves into trade unions and protecting themselves that way.
Thank you so much for that, Matt. If anybody doesn't have anything they want to jump in with, over to you, Louis.
So 2 examples. One, there's a power that the South African Human Rights Commission has, which I think at a structural level, it doesn't really help the individual victim, but I think at a structural level really makes a difference, which is their own ability in the gathering of evidence and information to create their own indicators and their own sort of process indicators, which is really helpful to present a sort of general picture of the country of how things are going. And I think, as we know, all of us in the room who work in these areas of rights, it's often quite difficult to make sure that government and other public authorities understand that what we're saying is not anecdotal, it's not an individual case, it's not a single experience. Is when there is really a structural problem that has been identified, that we know things are improving or deteriorating, having that sort of hard data to demonstrate, that the commission itself has, and I think is a quite useful way of working. The other really good experience that I'm particularly happy or proud of, which is a bit weird talking about good practice and talking about our own work, but I'll say anyways, but maybe self-promoting, but it's something that we've started to do at the commission just this year, which is to completely rechange the way we do our monitoring and our regional monitoring, and has been to really visit people in their places and spend months on the road visiting social housing communities, third sector organizations, etc. And so it's a very different way for an NHRI to do its monitoring. It's to directly witness the live experience of people, give bearing to that, be a witness itself. And again, I think it is a really instrumental way of echoing the voices of victims and charities working across the country, being able to quite unequivocally have those conversations with government and parliament, saying, I'm sorry, I've seen it myself, I've been there, I know the evidence, I know that. And I think, again, it's something within our mandate, within our resources, that other scrutiny bodies can do, taking outside of the desk and really being able to directly work in partnership with many people across the country. I think it's something I would want to see many other watchdogs like ourselves do.
Thank you, Louis and Nuala.
So again, this is quite a specific example, but the role that civic society played in terms of, assisting with the negotiation of those protections under Article 2 of the Protocol/Windsor Framework for the non-diminution of rights are really significant. The British government consistently tried to minimise the protections under Article 2, and those have now been tested in the courts. It was our local Human Rights Commission that raised the case that the Illegal Immigration Act was non-compliant with Article 2, and that case was successful. Now the UK government is appealing that case, but the outcomes of that particular case and the challenge under legacy has really indicated the paramountcy of Article 2 in respect of protecting rights, because now we're in a situation that if this holds, or even in this window, that if you can raise a case under Article 2 and it's successful, you're in a really, really strong position in how it can, how those protections protect, the rights of people in this jurisdiction. And certainly we're all watching the outcomes of these cases with great interest to see how all of this progresses.
Absolutely, Nuala. I was also just going to give another example of what I thought was really good practice in England. So, as folks might know, Section 1 of the Equality Act is about the socioeconomic duty. The Equality Act only applies to Scotland, England and Wales, not to Northern Ireland. But if commenced, the duty would require local and public authorities to consider ways in which their strategic decisions increase or decrease inequalities that result from socioeconomic disadvantage. Some people may know that Welsh and Scottish devolved administrations have gone ahead and enacted the duty essentially, but it isn't enacted yet across England. But we see voluntary adoption happening in lots of local and combined authorities. And actually another example of a place who have voluntarily enacted the duty is Merseyside Fire and Rescue. And back a couple of years ago now, we had an intern who worked with Greater Manchester Poverty Action intern to release a really, really great case studies document. Just think about what you're saying, Louis, in terms of like sharing the good practice that's happening. And in Merseyside, one of the things that they had done, they looked at who they were recruiting as firefighters, and they noticed like huge shortfalls in terms of women, in terms of people from ethnically diverse backgrounds, in terms of people from areas experiencing social deprivation. And the big barrier they were able to identify was that in applying to become a firefighter, you had to have a driving license. And that was a big barrier for all three of those groups, but particularly those experiencing socioeconomic disadvantage. And so they actually introduced a driving license bursary scheme. So it was no longer a prerequisite to apply for the job. And that massively changed the outlook in terms of people who were applying for these roles. And what I found so striking about that is that actually, first of all, them being able to use the statistics, but actually just giving these legislative things being brought in, not that socioeconomic duty is legislative yet in England, but bringing in these things actually gives staff the backing to make the changes that I think they know are the common sense changes, but actually it just pushes it over the line in terms of being able to get sign off, in terms of being able to give them the motivation that their ideas might be listened to, and in terms of allowing them to push innovative ideas forward and giving them the arguments to do so and the justification. So I just found that case study really interesting that way. Did anybody else want to jump in on anything on good practice? Because as chair, I shouldn't have jumped in, so I apologize. Okay, otherwise, I think we can move on to the third question. We are doing brilliantly in terms of time, by the way, folks. We are doing a nice little 15 minutes for each of these. It is the dream. So what would good look like in this area in the short, the medium, and the long term? What would the ideal scenario be? But also, what is one key change you'd like to see? And what difference could that one key change make? So I'm throwing it out there to whoever would like to pick that up first. Come on ahead, Louis. Thank you.
Just to break the silence because it's the tension on the screen. I mean, the one big change, I would go back to something I said before, which is we can't have the level of transformative change, at least in my view, without having our ESG rights domesticated into our legislation. And that's the first step. That the UK has continuously responded to the UN Committee on Economic, Social and Cultural Rights that there is no need for the incorporation of ESG rights into UK law because we have a various degrees of protections in our policies and laws. That's not my view. It's not the view either of the Scottish Human Rights Commission, which I can speak on this point. The reality is we need that. My day-to-day work, I can say as well, is that reality is that local authorities across our country, across the UK, across Scotland, across the UK, are in a position in which the reality is that their budget is so constrained that they will comply with their statutory duties. They will comply with what they are required by law. They will try to make sure they go way and beyond to provide with what they are legally required and can be challenged if they do. But anything that is not will not be the case. So you might provide housing, again, let's say housing as an example, but the way that the right to housing is framed as a human right in terms of its conditions of security of tenure, cultural adequacy, sustainability, habitability, location, that is not a requirement in any way. And so any challenge of progressively realizing, for example, the cultural or environmental habitability of a housing space will never really change. So I think that's really the first step in reality. And what would great would be is also coherence. We have a lot of sometimes legislations coming one side and the other side, and we need to step back and see how the policy coherence across government when these things are created are based on human rights and human rights mainstreaming. We need to think about budgeting, for example. Budgeting is essential. You know, at the end of the day, services and decision making, it's all about, you know, what's the available finance, or how much human rights influences the budgetary decision making framework, how money is allocated based on needs, on priorities. You know, we need that sort of system change. That's, for me, where we're at ideally in a decade or so.
Absolutely nothing said there that I would disagree with. Does anybody want to jump in?
I think just as well, if we're using the tools that we have, like greater transparency around how governments report against you know, the international instruments would be beneficial, because certainly in this jurisdiction we don't see any of the official reporting information. And, you know, for example, that reporting could be published through our executive office committee, and you know, that would allow people to see it, because sometimes there's confusion in that people see the reports from the commissions and view those as the official reports, as opposed to a challenge to the official progress report. So greater clarity on that would help. And I think as well, recognition and implementation of those statutory duties that do exist that are often ignored. And that's everything that has been highlighted here, from the, you know, the minimum wage duties right through, would vastly change the lives of individual citizens. And just picking up on what Louis said, you know, at one time, the executive, some executive departments did actually look at embedding the Brown principles into budgetary decision making, and it happened for like 2 years and then disappeared. So sometimes there are little elements of progress, and then as soon as a department changes hands in this jurisdiction, it's lost before you can even see the benefit of it.
Thank you so much for that, Nuala. Does anybody want to jump in on that in terms of what good would look like, Matt?
Yeah, so I think for the TUC and trade unions, it would be looking to have a rebalancing of power in the employment relationship. So I think a lot of people don't enforce their rights, particularly low-paid migrant workers, because they're scared of the repercussions, such as losing work or losing their employment status. Yeah, so I think trying to create an environment where compliance with labour rights is more of the norm, and I think there's a few ways you could do that. So I've touched on some of them already. So, for example, the right to access workplaces for union reps. So that has been set out by the Labour Party, but I think it's about making sure that can happen in all situations, in all sectors, and not just where there's existing union membership, for example. Reforming the statutory recognition process. So that's the process where unions can sort of compel employers to sit down at the bargaining table with them and talk about key terms and conditions. At the moment, it's very difficult for trade unions to reach those thresholds and show they've got the required levels of support they need to trigger those mechanisms. So we think that should be made much easier. For example, if you've got any union members, then there should be an obligation for the employer to sit down with the trade union to talk about what's happening in the workplace. And I think also that leads on to the final point I was going to make, which is about having proper sort of collective bargaining across the labour market. So that would be legislation brought about by the government that sort of facilitates employers and trade unions from a sector sitting down together to talk about what the minimum standards should be in that workplace, developing workplace policies, but also mechanisms for how those rights can be enforced without having to go to a tribunal or without having to bring in a regulator, and just and also communicating what those rights are to workers so they can enforce them quickly.
Thank you so much for that. Kate, you want to jump in?
Yeah, just to still follow up on just what Matt said there. I think that's like a really critical point that can really be extended beyond just the employment context, is that there needs to be sort of good, or would look like the responsibility for enforced rights not falling on the shoulders of individuals always, and individuals repeatedly making the same complaints over and over again for the same issues. And so that requires there to be systems where there's a much more proactive rights protection, that it's right, sort of a mainstreaming of human rights considerations in all decision making, so that they're trying to take moving back some of the responsibility and the burden of the protections, and also identifying ways that collective protection is secured, because if it's happening to one person, it's usually happening to many people. And I think that's an important factor in like what good looks like. And in picking up on Louis' point about coherence, it's slightly different point, but is that in the meantime, while people are having to be the individuals that are having to take enforcement action, is having much more coherent access to advice and support, so that people are not being pushed from pillar to post trying to find basic information, support in bringing complaints or legal action if necessary, having to go through their complaints over and over again multiple times to different people. And there's also an imbalance across the country. You speak to some people who say, well, actually in our region we don't have an advice desert, and simultaneously in another region there's a massive lack of any provision for advice whatsoever. And so measures like that are all important steps towards improving accountability, I think.
And I'm just going to use chair's privilege again to add in, just kind of building on some of what Nuala was saying. There was a requirement in the Belfast Good Friday Agreement for a Bill of Rights for Northern Ireland. So in terms of what good looks like, I mean, there was a huge and I think really important civic conversation that happened in Northern Ireland that was led by our Human Rights Commission, that led to some really comprehensive advice for what should be in a Bill of Rights for Northern Ireland. So I think in terms of the foundations of what needs to be built on, I think that process seemed to have informed a lot of what happened in Scotland around your own thinking for incorporation of these rights, in terms of getting people involved in these conversations and how we hold those conversations, who we include. And obviously Scotland have improved on that, and you've seen a lot more lived experience involved in those conversations. But I would love to see perhaps a new administration moving forward with that commitment to a Bill of Rights for Northern Ireland, because of course the important thing is that it was within the gift of Westminster to deliver, and therefore the mandatory coalition within Northern Ireland should not be a block to that development, because I also think there's something hugely powerful in the asymmetrical developments of rights frameworks across the different nations and jurisdictions of the UK. And although we would ideally love to see UK-wide rights protections, there's something incredibly powerful about the very complex tapestry of pushing rights forward in different ways. And Nuala, I think the recent Article 2 developments and the real teeth that has in terms of this application really just adds to that really rich tapestry. And for me, if we could get that Bill of Rights that's through Westminster legislation, that would really help to drive forward, I think, other parts of the UK as well. Did anybody else want to come in terms of what good looks like, though, before we move on to our final question? Okay, last one then. How do we get to good? So, for example, what are the steps that would need to be taken and who needs to take them? What are the things that need to be in place? And really importantly, what particular groups or communities do we need to think about and ensure barriers are removed for those particular groups? Anybody want to kick off?
Just going to give an example in terms of why it's important to include disabled people. So, and this is kind of emerging from the COVID inquiry as well. So recently we had our local module of the COVID inquiry which was centered around political decision making. And it really showed how not including people in decision making processes leads to bad decisions. And I suppose one example is that there was an initiative to feed people during the pandemic. It turned out that the executives' approach only reached 6% of the shielding list because they weren't working with the right organisations, and even our First Minister flagged up an example of working with GA clubs. You're not going to feed disabled people by working through GA clubs because they're completely different demographic of people. Sports people and disabled people are not the same. But it just shows kind of the lack of understanding that there is in terms of how to engage with people around decision making. Another key example is that the energy relief schemes that were introduced here did not reach, as in within Northern Ireland, didn't reach disabled people because they only went to people on means tested benefits, meaning that the population who were switching off life-saving machinery and most in need did not have access to emergency fuel support. So I think if you're to develop legislative approaches or anything around change, then people who are impacted by that change need to be in the room, and not just as a token, but as an ongoing, sustainable and consistent way through which, everyday people can influence policy and legislative change.
Thank you so much for that, Nuala, and really striking examples, and absolutely, yeah, thank you so much. Does anybody else want to jump in? How do we get there? Go ahead, Louis.
I mean, I think there are different venues, or they're definitely different avenues. I think there's a difference depending on the rights we're talking about. I think some of the things Matt has really well highlighted, which are really related to economic rights, to labor rights in general, have a different venue or a different avenue in relation to social rights, where the conversation is quite behind. And I'll just focus on social rights and cultural rights for a second because of that. I'll probably highlight two things. First, well, probably three, sorry. First, these conversations I think are really relevant, and I really welcome sort of Just Fair doing that, because I think that needs to happen across the UK. We need to sort of build an understanding and the support of going forward. So I think we're on the right step. Second, I'll just sort of share the spotlight into Rosella, who is in the room, who I'm very happy to see, which we did our LLM many moons ago together. And she and her organization do really phenomenal work at the global level. And there's so much wealth of experience and knowledge to be shared of many organizations working out with the UK that can help us in the UK to learn and not often have to reinvent the wheel. The wheel has been invented and work well in other settings, and we are, maybe because we're an island, quite insular at times, and we don't want to learn, and we sometimes look down at the developing countries saying, oh, we don't need their support. And I think there's a lot for us to learn from those perspectives, and that, I think, for me, is an important step we have to take. And the third, I would say, is on social rights particularly. We need to continue to convince the legal community about the value of social rights being embedded into our domestic legislation. I'm happy to say that I think in Scotland we have managed to move that, and that was a strategy of the Scottish Human Rights Commission for many years, to convince solicitors and advocates to get there. But we still have the and I'm still sometimes in rooms with lawyers in England and Wales where they really talk about social rights as woolly rights, or unquantifiable rights, or Marxist rights, etc. So until we have a quite strong support of the legal community of the value of social rights, domestication and justiciability, then we're going to continue to have those obstacles in any attempts to make them robustly and strong as possible in our laws.
Thank you for that, Louis. Rosella, I don't know, I'm putting you on the spot, but just in case you did have any reflections from kind of a more international perspective on what good might look like, you're very welcome to share them.
Thanks. As you know, I only work on the right to health specifically, but certainly something that can help is to connect with movements at grassroots level and empower them in a way that they can demand their rights, but at the same time prioritizing research, collecting data, human rights indicators, and not working in silos. So constantly speaking to different movements. And I'm also talking about the human rights movement per se. For instance, what has worked really well in health is to connect with public health organizations, unions, so going really beyond human rights. Which is really, really key in the field of social rights and specifically, in my case, health. And also, I'd say not forget, as Luis also was saying, the international level, trying to connect with the international level, the regional level, etc.
Thank you so much, Rosella, and apologies for putting you on the spot, but you did fantastically, so thank you. Did anybody want to jump in on that kind of how we get to good, who we need to think about? Matt.
Thanks. Yeah, I was just going to pick up the last part of the question about what particular groups or communities do we need to think about to make sure barriers are removed. So just wanted to flag that, as I've talked about, like vulnerable migrant workers already, but I think there's some groups of workers who are really, really difficult to reach, and they have total sort of lack of support networks, whether that's community networks or often they'll be travelling without their families coming to work in the UK, and they don't have access to a union. So if you're on a really short-term visa, it's unrealistic that you're going to have a union get in touch with you to offer support. So I think it's important that the statutory bodies who are responsible for enforcing rights take into account those people. So, for example, you've got Unison, who are really good at organising migrant social care workers, and Unite have successfully organised overseas domestic workers, and then frontline charities are doing a great job as well, but they really struggle with resources. So one of them flagged up to me today actually that what they wanted to see is to establish labour market inspectorates dedicated to engaging with vulnerable and isolated migrant workers. And these inspectors should be from the same linguistic and cultural backgrounds as the workers themselves and trained in trauma-informed approaches. So I think that was a really important point about how we reshape the enforcement system to properly engage with people. Like a big problem is looking at the demographics of the existing inspectors themselves. Like a lot of them are drawn from a police background and they're a certain age and they're white and they're male. And then you expect those inspectors to go and understand the issues which like young vulnerable women who have been sexually exploited might face. So it's about, I think, reshaping the enforcement bodies to make sure that you can properly engage and listen to the people that you're trying to help.
Thank you so much. That are hugely important reflection in terms of also like having the correct messenger to bring these things in. So thank you for that. Did anybody have any final reflections? Otherwise, we might be able to close up a couple of minutes early. But I just want to say, I think we're dropping a little bit, maybe getting later in the evening, but huge thank you to everybody for taking part. This, as always, has been so massively helpful for us, and like all the really incredible thoughts that you've all shared, and also the way these thoughts are interacting off each other, it's just been so hugely valuable. So Just Fair, on behalf of Just Fair, I just want to say a massive thank you to everybody who came here tonight, and particularly to everybody who spoke for us. So we hugely appreciate it. If you do have a few minutes, we would obviously love you to share some feedback. But what we'll do is we'll share a follow-up email tomorrow as well, and just with how you can sign up for the next session. But hope you all have an absolutely wonderful rest of your Tuesday evening, and we hope to see a lot of you later on in June for our next session. But thank you so much, folks. We hugely appreciate it. Bye-bye now.
Thank you very much. Bye-bye.